Hi, everyone. I'm Mary Beth Moylan. I'm a professor here at McGeorge, and I am very pleased to get to be the first one to talk to you, not the last. First, I want to pitch that my students, many of whom are here, in the California Initiative seminar, will be doing not one, but 2 public forums. So if you're wondering, how should I vote? What is going on with those 10 statewide ballot propositions? Please come and join us, where the students in my seminar will give objective and neutral analyses of each of the 10 statewide ballot measures. We're doing it next Tuesday at 5:30 in the lecture hall, and we're doing it also again at the Kennedy Learning Center in the federal courthouse on Thursday, October 24th, from 12:15 to 1:30. So you have 2 opportunities. The October 22nd, Tuesday evening, California Initiative Forum will be live streamed. So if you can't be here on campus, don't worry. You can watch us from the comfort of your home. And we'll be happy to dispel all the nonsense, all the sound bites, all the crazy ads. If you just want to know what's really going on, come and hear us do that. So that's my pitch for the California Initiative Seminar. That's part of the Capitol Center, which is what is also sponsoring this wonderful event. We are so happy to have retired Chief Justice Tani Cantil-Sakauye here with us to have this conversation with our very own Professor O'Neill. I'm now going to introduce Professor O'Neill. I think that's what I'm doing. She is the director of our Capitol Center for Law and Policy. She is a professor here at McGeorge. She teaches lots of things. We're super lucky to have her, and I'm going to hand it over to her. So there we go. Thank you.
Thank you. Welcome, everyone. It is so wonderful to see the turnout this evening. We could not be more excited to welcome the former Chief Justice to our campus. I am Erin O'Neill. I'm a professor here on campus, and I direct our Capitol Center for Law and Policy and also our Capitol Lawyering Concentration, which is a program of study for students who are interested in careers at the intersection of law and public policy. I think our guest tonight embodies that kind of the career trajectory. And I wanted to say thank you to our many Capitol Center board members who are here this evening. If you haven't had a chance to meet them, students, they are wonderful amongst the crowd. Our Pacific Legal Advantage students joining us from the Stockton campus. Our many students here on campus and our co-sponsoring student organizations for the event. The McGeorge Women's Caucus, Women of Color Collective, APULSA, and also CLASS. And on that note, I would like to welcome Mahima Karia up front to introduce the former Chief Justice, and then we will get started. President of Women of Color Collective.
Thank you, Professor O'Neill. I am so excited to be here today. In fact, when Professor O'Neill asked me if I wanted to do it, well, she asked me and my co-president, Daisy, if we wanted to do it, I immediately texted Daisy and said, "Let me do it, please." Thank you. So without further ado, it is my honor to introduce someone who has made a tremendous impact on California's legal system and beyond. Currently, she's the president and CEO of the Public Policy Institute of California, where she leads efforts to improve public policy through independent, objective research. But many of you might know her from her incredible 12-year tenure as Chief Justice of California, a role she stepped into in 2011, where she made history as the first person of color and only the second woman to ever hold the position. During her time as Chief Justice, she became a strong advocate for equal access to justice and reforms that made our court system more transparent, efficient, and fair. She focused on addressing the unfair financial impact of court fees, fines, and the bail system, especially on lower-class individuals. Under her leadership, the judicial system became more open. She made public meetings available online, improved how courts handled workplace issues, and championed remote court operations through the pandemic. She's also been a leader on important issues like implicit bias, human trafficking, and civic education. Her work to promote civic learning through her Power of Democracy initiative earned her national recognition, including the Sandra Day O'Connor Award in 2019. Before becoming Chief Justice, she served in various judicial roles for over 20 years and began her career as a Deputy District Attorney and member of Governor Deukmejian's senior staff. She has a BA and JD from UC Davis, but her most impressive credential is the lasting difference she's made for Californians. Please join me in welcoming Tani G. Cantil-Sakauye.
Thank you. Thank you.
Okay, to kick things off, let's start at the beginning. So what inspired you to go to law school and pursue a career in public service?
Thank you, Professor. It's a pleasure to be here. I consider McGeorge my school away from school. This is where I studied for the bar exam to get away from all my friends who could only wring their hands at UC Davis. I'm also here with our Vice President at PPIC Government Affairs, an alum from McGeorge, and also a longtime legislative person before she came to PPIC, Deborah Gonzalez. I also want to call out Susan Madinat, who helped me with civics and helped it get off the ground. But I will say I never planned any of this. I just showed up and probably couldn't keep my mouth shut and did the best I could under all the circumstances. So I went to law school because it was something that I'd grown up around a lot of injustice and wondered why things happened the way they did to my family, to property, to people's rights, to marriage, and never understood why. And then later on, as I became more, I think, educated through community college and people who were there and why they were there and what they were looking for, led me to do other things. And I found myself in speech and debate with people from other colleges, like USC and other four-year universities who were competing in speech and debate, and they were going to law school. And that's when I thought I could go to law school because I'm beating them. So I could go to law school if they could go to law school. And so when I went to law school, I didn't know a lawyer. The highest grade achieved by my parents was like second grade for my father. And my mother, I think, got a community college degree when she was somewhere in her 50s. So there was no really role model to speak of. And I found that at UC Davis, there was not, those were the days when there weren't really internships and there wasn't an internet, so we were all kind of like three blind mice trying to figure it out. And so I went into public service, primarily because I went into private practice during one of my summers. And for me, I was like a mole rat. I spent all day, late into the night, in the library doing research and writing. And then as soon as my product was done, they would take my name off of it and put someone else's name on it and bill otherwise. Plus, it didn't help that they told me, we are a patent leather shoe outfit and all of our women wear skirts. Mm-hmm. So, this is like 1982 and no one's ever talked to me like this. And I think this can't be where I spend my life. So I went into public sector. The first job I could get, probationary prosecutor in the Sacramento County DA's office. It's not so much why I went into public service, but why I stayed. I stayed in public sector because I received more responsibility and more autonomy and more agency and more independence than I ever would have had in a law firm. I'd still be in that library, I think, if I were in that law firm. So that's why I stayed, because I found I could have a voice and a say, and I tried my own cases and got in trouble when they didn't go the right way. But it was my trouble caused by me. So it was more of an agency and a commitment to doing something that I thought would help the public.
Sure. No, that makes a lot of sense, and the ability to, like you said, kind of chart your own course.
Yes,
versus
exactly.
having someone else chart it for you.
Right.
So speaking of that, did you know you wanted to be a judge? How did that develop for you?
Oh, absolutely not. I didn't know that I wanted to be a judge. I wanted to be a prosecutor. I just loved trials, and I wanted to be that. I think my only real thought was I would be that forever. I loved being in trial. It was all-consuming. And at the same time, being in Sacramento, which is not a place I wanted to be. I wanted to be in San Francisco. I applied for the public defender's office in San Francisco, and I was turned down. And I was turned down because they said, we don't think that you can hold your own in a courtroom. And this was, okay, I didn't get a job there, so I went to Sacramento and tried out in the DA's office and was given a job. And so I never thought about being a judge. I didn't even know then how you became a judge. They didn't have programs or how to become a judge or judge mentoring in those days. But I loved the idea of taking interviews and trying out new jobs. So I interviewed at the governor's office for an attorney spot because he had a small legal team, Governor George Deukmejian. And I thought, I have no chance in getting this, but I'm going to take the interview. And I was really lucky and fortunate to get the job offer.
Excellent. So from the point at which you decided to become a judge, you were Sacramento Superior Court judge, and then you were with the 3rd DCA, and obviously finally chief of the California Supreme Court. How are those roles different, similar? How would you compare and contrast?
They all are symbiotic in many ways. So once I went to the governor's office, all of a sudden all my lawyer friends and other judges were being really nice to me. And I would appear for the governor, and then the judge would say, come up here. And I'd go to the sidebar, and he'd say, put in a good word for me. And I thought, what is he talking about? And then, the light went off. The governor appoints judges.
He does, yes.
And then someone said, a judge is just a lawyer who knows the governor. And I thought, what are you talking about? So my first job was on municipal court. And it doesn't exist anymore. It's been written out of the Constitution, but you only needed 6 years experience as a lawyer, and I had 6.5. And so I was able to get onto the municipal court bench because at the end of every governor's term, he likely tries to place his inner staff. So they came to me and said, well, the governor's not running for a 3rd term. And so would you like to go to the bench? Would you like to go to the AGs? Would you like to go to lobby? What would you like to do? No promises. So that's how I got to the bench, the municipal court. But a trial court of record, like now it's only a superior court in California for every one of the counties, it is really different because that's the place where all of the action takes place. That's where the jury box is, the witness stand, live testimony. It is the place where the record is being made. It's what we call the drama. The drama is happening in the superior court. So it is a place where if it doesn't happen on the record, it didn't happen. And so at a trial court, the judge is trying to get to a decision, make a record, and move on because it's going to go up on appeal. So as a trial judge, I would make 200 decisions a day. I would be picking juries. I would be trying to negotiate plea bargains. I'm immersed with lawyers. I'm shoved in elevators full of people every day. It's just a constant mass of people every day. But at the municipal court or the superior court, you're trying to make a record for appeal because the case is going to go up if it's a felony or a civil case above a certain amount of money. And so at the appellate level, it's an entirely different ballgame. Now I'm sharing the bench with 2 other justices, and we need at least 2 of us to agree on a decision. So the first floor of the judiciary is the superior court or the trial court, activity. But when you go to the second floor, the appellate court, it's like we say you read the book. So the first floor is you watch the play, and the second floor, the appellate court, is you're reading the book because everything is on record. You're reading what happened in the entire trial, looking for prejudicial error. The difference at the appellate level is there's no new fact-finding. We are bound by what the jury found or the evidence that was produced, and we have different canons of construction that really control a judicial officer. There's judicial restraint that comes from how we interpret the cases. And we are looking, and we're bound by standards of review. Abuse of discretion, de novo review, mixed de novo and substantial evidence. So it's meant to restrain us at the appellate level, because at the appellate level, we're only looking for error, prejudicial error. So it's a very different atmosphere. There are no people in the appellate court. There are no people milling around. I don't know if you've ever visited an appellate court, but an appellate justice is a quiet, monk-like existence. You are with your clerk and your 2 research attorneys. And in order to talk to another justice on the case, because you need 2 others, you've got to travel through, at least at the 3rd, locked doors and elevators. It's a real intentional effort to actually have face-to-face contact. So you have to be a self-starter at the appellate court because you have to get through your work. You have to get through your cases. And they just come rolling in store carts. Doghouses are coming in, doghouse after doghouse after doghouse. It's the record at the trial court below. And so you have to show up every day and be willing to jump into that doghouse and start looking and seeing what the parties are briefing in terms of you getting to a decision. Then you have to go find your colleagues and get to at least some kind of majority consensus. But the courts of appeal, of course, are constrained by precedent. And so they follow the rule of law, and they probably create more law in California than any other level of court because they are workhorses. They are courts of error review. They are looking for error. And so it's a very different task than the Supreme Court. If you lose at the appellate court and you go to the Supreme Court, you petition for review, which is a nice way of saying you ask the Supreme Court to take your case unless it's a death case or some other case. And there's 7 of us. And there we take a long time with 7 different opinions, and each justice has his or her own law firm, basically. I have a law firm as chief. I had 9 lawyers. I had 3 judicial assistants. I had a whole army of administrative people, about 800 administrative people, because the chief runs the judiciary. And I'm working with my colleagues, and we each have the same vote. They don't care who's chief. 1 vote, 1 case. And there we have to work with each other and try to accommodate each other to try to get to a written rule of law that applies to all of California. So you can imagine 7 people who worry about punctuation and commas and when you use the semicolon. And we all give ourselves these deadlines because I need to know how you think 60 days in case I'm going to write a dissent. And I need to give you 45 days to respond to my dissent. And so we are very, very time-oriented at the Supreme Court. And we're very respectful of each other because there's only 7 of us. So we see each other all the time. We sit at the chief's table. We look at each other. We disagree in person. And we all try to get to the rule of law, which means looking at all the different decisions of the courts of appeal and trying to find a way to pick the best answer. Because at the Supreme Court, there's multiple good answers. That's why it's at the Supreme Court. There's multiple good answers. We're trying to find the one that fits for the rule of law for California. So it's very different. Trial court is verbal and listening, I want to say. And the Court of Appeal is writing and counter-writing and rebuttal. And then the Supreme Court is just a massive trying to integrate all of this information into writing a coherent decision.
Sure, thank you so much for the overview. That's interesting to think about the interplay, right, between the branches and how each have their distinct identity.
Yes,
that
yes.
contributes ultimately to what's the rule of law here in California. And apologies for the microphone cutting in and out here. So, as was mentioned, you were the first person of color and the first woman to serve as Chief Justice of the California Supreme Court. What was that like, and how did that Trailblazer status impact judging? Do you think it had any sort of influence on your judging?
Thank you. I'm not certain. I have to say, I had 20 years in the trial court and the Court of Appeal before I went to the Supreme Court. So it wasn't like I had a meteoric rise, or that is the slowest meteor you've ever seen. It's just that in that time frame, I had gotten used as a prosecutor to a lot of people looking at me and asking me, how old are you? Or when I went to the governor's office asking me, well, when do you think you'll pass the bar? And I would say, well, 6 years ago. So there was just always a lot of question and, lack of confidence based on appearance. So there was a lot of proving and reproving in cases with juries, particularly because that's the first time they're seeing you and that's the last time they're going to see you, unlike judges and lawyers. So I will say being at the Supreme Court was truly unique and different, but I will say I had been pretty conditioned along those 20 years in my time as an attorney so that it didn't feel foreign to me. I knew the reactions. And a lot of the reactions were just curiosity. Who are you? Where did you come from? I will probably say I was a surprise candidate. The legal papers, the Daily Journal, the Recorder were all publishing all the names of people who could be chief. I wasn't in the list. They were online talking about who it would be. It wasn't me. I was talking about it too. Oh, it's going to be so-and-so. And then I get a call. So it's not as if I was known. And so it was humbling. It was humbling to remember that this was a first for some, a first person of color in California. And so I will say, what was that like? The love and support was overwhelming. At my commission hearing, I don't think the Supreme Court has never held that many faces of color all at once. Never. And people who I didn't know and organizations I didn't know came to speak at my enrobing ceremony and different events, to speak at what it meant for them in a place like California to have and be able to have the opportunity to ascend and to be an equal and to lead. So that was remarkable to me because, as lawyers, we're in this tunnel vision of I got a case, I've got to go to court, I've got to win. And, in the judicial branch, you're just dark and I'm in my courtroom and I have a case. So it was an eye-opening event to see so much love and support as being the first. It had its challenges because also there were people who were skeptical and people who had bias and judgment ahead of time. And it was just about showing up and being there and doing the hard work and showing up and going toe-to-toe sometimes in a respectful way that eventually they got used to me, I'll say. Being the second woman drew a lot of comparisons with Rose Bird, the first Chief Justice female. And she was just from a different time and place. I would not have envied her task of being the first woman in that time frame because she inherited, frankly, a bench of colleagues who were probably not welcoming, not warm, not diverse. When I became the Chief Justice, soon thereafter we had a majority of women on the bench for a long time. When Goodwin Liu came along, we had, lo and behold, a majority of Asian Americans on the Supreme Court. I'd look at Kennard, I'd look at Ming, I'd look at Goodwin, I'm like, how did this happen? Because we are not representative. It was just California's a different place. And I had a much different experience than Chief Justice Rose Bird.
Sure, yeah, absolutely. So as far as your interest in policy and the shift later in your career into the Public Policy Institute of California, how did that happen for you? What do you see as the judiciary's role in the policymaking process?
Thank you. That's such a great question, and I'm so happy to hear that you're the head of law and policy, because law and policy are siblings. They're very close siblings. The law is a result of the policy decisions made by the legislature, approved by the governor, signed into law. But which comes first, law or policy? I think they're very symbiotic. It was probably only at the appellate level and the Supreme Court level that I began to really think of how policy really turns and affects and changes the law. It is the policy makers who think about this law that we need and then engage in it, do the research on it, and then write it out. In the judiciary, even at the Supreme Court, the highest level, we're merely interpreting a law that's already been written. The policy has been cast. We don't have a say in whatever the policy was, and the law is meant to implement that policy. So many times on the Supreme Court, one of my colleagues would say, well, what's the policy behind this? Because we're really saying to ourselves, this doesn't work. So what was the motivating, animating factor for this law? So at the appellate court and the Supreme Court, I became acutely aware that the policy could be something that's improved, that could be more inclusive, that could be more collaborative, that needed more data. And the Public Policy Institute of California had always been just a leader in this area, a leader of nonpartisan independent research that I had relied upon, used in speeches, been to their events. So it was a matter finally of saying, I want to be on the front end of policy to influence law. I've been on the back end of law, and I can tell you that in the judiciary, we're not to create new law. We interpret it, clarify it, maybe extend it if we think that's fair, but that's not our first job. So also at the Supreme Court as the Chief Justice and heading up the judicial branch of government, we get to actually implement policy. We get to take policy to the legislature, like Mr. Cooley, and actually ask, will you pass this bill? Will you support it? Will you author it? Will you propose it? We need this change in fines, in fees, in sexual harassment, and in the environment. So I was lucky as chief to be able to actually think of policy and take it to the legislature and try to get it passed into law.
Sure, so on that note, what's your proudest policy accomplishment and what was the biggest challenge that you faced?
I'll start with the biggest challenge.
Sure.
The biggest challenge on a policy level is to try to get pro bono, low bono services for people in need in California. It's a multi-pronged issue. The first is, right, that the courts are set up with certain limitations where cases that are, and I forget completely the amounts, but Some cases at $25,000 go to small claims court where you can't have an attorney. Cases $50,000 and over go to Superior Court as civil unlimited, then there's civil limited. The trouble is there comes a level of the worth of a personal injury case that lawyers won't take. It's like, well, it's only worth $100,000 at best. It's only worth $50,000 at best. Recompense for that kind of injury. Plus, the other aspect of litigation in the civil world is that attorneys are expensive. And California has a high need population of people who need legal services. 3/4 of civil cases in California have only one attorney on one side. It's harsh and it's uneven. And you have a better outcome when you have two attorneys. So we were trying numerous ways to encourage, incentivize, and require attorneys to volunteer time, or to, instead of MCLE, the continuing education, give your time to represent people in need at the courts. And we had a hard time passing any of that. California remains a high need state for civil litigation and representation across the board in some of our most high need cases: family law, landlord-tenant, workers' comp, injury, personal injury, but also employment law. And so there's a huge need to try to get more services to that population. And I've tried numerous ways: incentivize, carrot, stick. Here's the problem as chief: everyone agrees with you. But then after you leave the meeting, you find out that you really don't have the votes. So that was the hardest, and it's still a challenge because California is even more so high need nowadays. But some of the best policies, I will say, came from struggle and came from, we were being sued. Los Angeles is being sued. Our biggest trial court is being sued. I'm like, what? Why is that? Well, because there's a complaint that we aren't providing sufficient language access. And I say, what do you mean? We have 200 dialects spoken in California every day. We provide the best and the greatest of interpreters and translation. And US DOJ is like, that's not enough. And so instead of fighting them and saying, what do you mean that's not enough? I just embraced language access and said, you know what? We're going to open a big committee. We're going to find out where we need language. We're going to find out what services we need. We're going to pull in civil, criminal. We're going to provide translation and interpretation at the desks. We're going to provide it for any court-ordered counseling. We're going to provide, and we're going to go to the governor, and we're going to ask for money. And that happened. It happened, and I think that it took, embracing a problem rather than fighting it. The same was true for fines and fees. I was always of the view that Jeff Bezos and I should not be paying the same for a speeding ticket because it's supposed to be, rehabilitative but punitive, and it's not punitive to him when he pays $400. It's only punitive to me. So isn't our system, doesn't it need to be adjusted? Don't we need to look at this? And so we have developed a sliding scale, and we can do this online, and it's an ability to pay, and we're really trying to pioneer more and more of it. I will also say that for years, we were trying to automate the courts to provide more remote access, more tech, but we were really prohibited by some legislation. We were really getting pushback from labor because they saw it as a way that maybe people would lose jobs. We promised you not lose a job, we'll just re-engineer space and work for you. But when COVID hit, which sounded like the death knell for in-person court hearings, we capitalized on it. We immediately went into remote gear. The governor gave me unprecedented power to suspend all statute at that time, which was like, I have it framed. What? And I promised him that I would be judicious. But the point is that kind of crisis caused everybody on board. I had lawyers who are typically at the top of their game and, maybe more senior in their experience, having to do oral argument at the Supreme Court remotely. So now their clients could see them, everyone could see them, their mother could see them. And there was a lot of trepidation about, oh no, I can't do that. So we walked them through, we did mock oral arguments, we helped them with their tech. And now it is an enduring piece of practice in California, but it really grew from fear and concern, but we turned it into something that could work.
Sure, absolutely. I teach oral advocacy and taught the year during COVID, and we had to learn this new skill of advocating to the camera, not the screen, and all of the things that you need to do in order to be effective. And it is enduring. I mean, it's interesting the way that a crisis can force change that then becomes normal, right? Yes.
Accepted and welcome. And it's just an option. You could still show up in court if you wish.
Yes. So over your long career as a judge, most memorable cases, what will stick with you as you go forward?
That's a good question. After 32 years, I've had a lot of cases. And I will say that the cases that stuck with me the most at the trial court and the appellate court, and a little bit at the Supreme Court, are the juvenile cases. Because in those days, we didn't have the changes in law, so I was finding myself sitting across a 16 and 17-year-old saying, okay, the offer's 38 years. I know it sounds terrible, but if you go to trial and you lose, you're looking at life. And maybe you'll have 15 years, you'll have an opportunity at parole, maybe. So trying to talk to young people about crimes they committed together where no one was really hurt, but when you brandish a gun and you throw someone in the backseat of a trunk and you kidnap and other things that are happening, it's hard to comprehend. And so I have probably sentenced back, and they have been resentenced since, but those early years of juvenile sentencing was really hard, trying to talk to people about bad behavior that really had onerous consequences. I think, too, there were some cases at the appellate level, less about juveniles, but more about civil, like the rules we are making in civil law. But at the Supreme Court, the case that continues to endure for me, because I did not know that it would have the kind of legs that it does to this day, the United States Supreme Court just turned down a challenge by Lyft and Uber, is Dynamex. It's the case where in California, we never knew whether someone was an employee or a worker was an independent contractor. And it has legal consequences for the employer and the worker. But more importantly, when someone isn't an employee and they're a worker, they lack all the benefits and the protections that an employee has. But what that means is if they lose their job or they become ill or they become injured, then they turn to the public fisc. And we have a public service that can help them, but it's not enough, and people suffer. So we had a question of law, the test for when someone is an independent worker or an employee. And we also determined that there's a policy basis behind this. This is where public PPIC really, in my mind, came into my thinking in that case that I authored, and that is the policy of not seeing people who do the same job as an employee means that they suffer loss of benefits, and that loss of benefits affects people who live here and pay taxes, who now have more taxes to pay for their medical care, for food, for school, across the board. So why should we taxpayers pay that burden when they work for and were a worker for a company that could afford to pay these benefits? So I had no idea that the legislature would turn around and make that a law, and that it would be litigated some 9 years later everywhere people turn. But I still think it was a good rule to have a test. This is the test. Either you meet the test or you don't. And I think ultimately it covered enough people to give benefits.
Sure.
And so we are in a different place as a result of something like that. And that's the only time you can do something like that is at the Supreme Court. But I want to say it's not a new test. We borrowed it from Indiana. Indiana hasn't gone up in flames. So California could possibly do this as well.
Yes, absolutely. No, that was an antecedent of a lot of big policy conflicts in California that continue to this day, as you said, but such an important thing to get out there and be able to evaluate with a legal test instead of just arguments back and forth. Yes. So your role as CEO and president of the Public Policy Institute of California, what's that like? How did you know you wanted to move into that space? What do you do on the day-to-day?
Thank you. That's a great question. Well, the Public Policy Institute of California is the premier research institute in my mind in California. It's 30 years old, which for an independent, nonpartisan research institute or think tank is phenomenal because we're not an advocate. So in other words, adversaries and people who take positions on bills and ideas, they don't give us money. We only take money if you want the research done. And then good advocates can take that research and decide how to use it in argument. But at PPIC, we don't support legislation or candidates or ballot initiatives, but we seek the data, and Deborah is our chief data officer, McGeorge trained, and contracts, and gets us the data that allows us to do the research where decision makers can understand the issue and make better decisions for all of California, not just based on argument and feelings. And I was very interested in PPIC my entire time as chief because of the work they did, which is very Supreme Court adjacent, very court adjacent. We only, courts of review, Supreme Court included, only start with the facts. Now, the facts are determined by a jury or by a judge on a bench trial. But we don't go making up facts or looking for new facts at the Court of Appeal or the Supreme Court. The facts are what we start with. And that's the same with PPIC. The facts are what we start with. And from that, we determine the best policy or the best routes, or we point out where the policy has failed. So for me, it's very similar to the work being done in the courts with the facts. Let's get the facts. Let's start with the facts, and let's decide where we want to pursue and have and put our energy. So as the president and CEO, I work no longer with lawyers, I work with researchers. And these are folks who are either PhDs or masters, and they're experts in their field. And we study about 8 different research areas. And we know they're important because they all follow the governor's line item budget. So where California puts its money, that's what we study. Are your policies working? The money that you are providing California, is it actually resulting in the promise that you made? So we study higher education, the community colleges, the CSUs, and the UCs. We study TK through 12, all the new changes in transitional kindergarten. What's that going to do now that all young children are eligible to actually enroll? What does it mean for kids in the Central Valley who maybe don't have access to the same level of education, where the schools don't teach the A through G requirements to get into a UC? I mean, we have all of these kinds of studies about where we can better improve policy in TK-12 and higher ed. We study economic policy in California. Who's working? What are they making? What do we need to improve? We know that the Inland Empire, for example, had a growth in employment, but we also know it's low-wage jobs. We also know those are not paying the mortgage. They're not paying rent. Yes, there's an explosion of jobs, but people's economic status is not improving. What's it take to get people to improve? How can you buy a house in California? How can you pay your rent in California? We study criminal justice and criminal justice reform. We just did a study on Prop 47, and soon we'll have a study out on emergency bail orders, and whether or not CDCR, the prison system, actually does in fact educate and rehabilitate people for reentry into California, given the billions that are spent in the penal system. So we study those kinds of issues, and they resonate with me because they are the seeds of change. And if we're going to change in California, we need to start with the facts. And the facts are what PPIC produces.
Sure, and you just mentioned what resonating with you. So how do you see your background, education, experience, everything that you've done over the course of your life informing your policy perspective as the leader of PPIC?
Thank you. Well, I am always, every day, impressed by the brilliance of our researchers and their depth. And we get subatomic on facts. Like, we get granular. And then I think, wow, this is so granular. Who's going to use this? And then I'm walking down the street and someone from SEIU comes up and says, hey, I read your report. We're going to use that subatomic fact in our argument to the governor. So I realize there are people out there reading it who can use it, who are making it their goal. For me, I will say I'm grateful to be with such brilliant people who are dedicated to the research, the pure research of it, producing it. And I will say from my background, as a lawyer, I think, how is this going to be challenged? As a lawyer, I think, is this fair? Who will not benefit from this? Are we saying this also as a lawyer? I say, are we using the kind of language that communicates, or are we alienating people with this language? And then as an appellate justice, I think, is this enduring? How will this work with other rules, other laws? And I always think if this gets to the Supreme Court, how will it be challenged? Because, amici comes in and has lots of different views about different changes in the law. And I'm always thinking about litigation. And I'm always thinking about the enduring aspect of legislation and rule changes and statutes and guidelines. So I think having that analytical mind that McGeorge teaches so well, how to think about something, how to be expansive in your thinking, what's relevant, what are the touch points really matter. And I think for me, I learn every day, but I also have a lot of questions about how things work, operate, and are written.
Absolutely, and that seems to be very foundational in terms of your career and then your work now. Very valuable experience for sure.
Yes.
So in your assessment, what do you see as the biggest policy issues facing California right now? I mean, there are so many, but...
Well, I will say we also have one of the best surveys in California. We do about 7 to 8 of them a year. And it's a survey that's quoted over all of the media, including the East Coast. So I will tell you some of the survey results that I think are concerning. So we have a survey out earlier this year, that said, and we survey voters, likely voters, across the board, Dems, Republicans, independents, nonpartisans, people who aren't partisan. It's really striking when they have told us that of 70% of the people who've been surveyed tell us that they believe their children will not have a better life than they have now. And that's really striking in California because my parents came for a better opportunity. We have this educational system that is first class and that is respected throughout the world. We have opportunity, we have Silicon Valley, we have innovation, and yet 70% of the adults who live here are concerned that their children will not have a better life than they have now. And that's an economic issue, that's an inflation issue, that's an employment issue. Also, I think, too, it's important to realize that in California, we lead on so many policy issues. But at the same time, we have, our Economic Policy Center is looking at this, we have a labor force that we're concerned about. We're concerned about our labor force because, A, the birth rate is flat. We're not producing young people. We're not happy. So school enrollment's going to be on the decline in K through 12. What does that mean for us? Also, we know that deaths are up since COVID. So we know our population is changing, and also we know that our population is getting much older, which is going to be a demand on medical, a demand on custodial care. And we also know that the boomer generation that is retiring and leaving the workforce, they have the single highest level of bachelor degrees than any other generation that currently exists. The Gen Zs, the millennials, the Gen Xers, across the board, this brain drain is leaving California, or retiring, maybe to still live in California, but leaving the job market. We also know that we have an education deficit. So we know that there's a group of young people, 18 through 34, that we have lost track of because they're not in school and they're not working. And we really don't know where they are in terms of employment or education. We also know that our higher education system is not working well, or frankly failing at community colleges. And we're failing in particular Black men and Latino men, who have the lowest enrollment and lowest graduation rates. We have a lot of concern about costs, housing, education, inflation. So I think we tell the story of California through its policies and its policy results, and we have a lot of concerns about the future. We have an initiative called Understanding California's Future, which is looking at the demographics of California and what that means. It's looking at the politics and the elections of California and what that means. It works with the Economic Policy Center, it works with higher ed to find out what's California going to look like 10 years from now. I know the California I live in is different from the California that I grew up in, frankly. It's constantly changing. So we're looking and concentrating our efforts in employment and education, safety net. We study those families and the support for families and individuals who need help from time to time in their lives with food programs and health programs. And we're really trying to inform policy to improve people's lives. So it's health, it's education, it's employment. And we're trying to get that into the legislature. We have a huge water policy center that is on climate and water and sustainability in California, and it talks about sea rises. It talks about our ecosystems that are just dying out. We're talking about our lack of water structure, lack of fresh water, and the concern about regulatory rates to build new infrastructure to provide clean water in the future. So I don't want to be a doomsdayer, but we at PPIC study all these aspects in order to better inform what the policies will be so that the decision makers know what they face and craft solutions and laws that will improve these areas.
Sure, and so important to have that background information. It strikes me listening to you talk about both your role as a judge and also your current role, that this curiosity and this love of learning and this wanting to understand how things work and make them work better is kind of an undergirding of all of these roles that you're talking about, and such important work. And from your perspective, we have a lot of students in the audience who are interested in careers in government and policy, maybe hoping to be a judge someday. Any recommendations? I want to open the floor to questions, but want to get your words of wisdom for sure before we do that.
Yes, I would say, I can't, to your earlier question, when did you want to be a judge? I never wanted to be it. I will say I wanted to do the best I could in every job, but more importantly, there's going to be a lot of jobs out there that aren't going to be your fit, but you should take all of those jobs and get the best out of it for you. You should build your foundation, your skill set. So it might be patience, it might be legal writing, it might be collegiality. You might need to break out of your shell and become an extrovert when you don't feel like it. You'll need to learn these skills in these jobs that aren't necessarily exactly what you want to do. But it's building yourself and building to something greater. And I think the best way to describe that is prepare yourself for opportunity. You don't know what it's like. I could never have imagined what I would do. I just knew wherever I went, I want to do the best I could and get some skills from it that would help me in the next endeavor, whatever that might be. And I also think, too, you should think big for yourself. Think big. And take interviews that scare you. I took the interview with Arnold Schwarzenegger for the Chief Justice position thinking, oh, the governor is interviewing all the people of color and women, and I'm the twofer, so I'm just on the list to be interviewed, so he can say, I interviewed a wide range of diverse candidates. And I said, I don't care, I still want that interview. I still want to go in there, I want to have fun, I want to see him face to face. I don't care, that's what I want from this interview. Did I go in thinking I wanted chief? Oh, no, I didn't think that. I never thought that that's what he was aiming at. And so I think you should don't make assumptions. Take the interview and build your brand and foundation.
I love that. Dream big, yes, and take the interview. That is a good piece of advice. So opening the floor to questions. Anyone, questions for the former Chief Justice? Don't be shy, this is an opportunity. Yes.
What would you say the most important step you took in your career towards working in public policy was?
Thank you.
What do you think the most important step you took in your career towards public policy was?
Thank you. I think my most important step working toward public policy in California was when I interviewed in the governor's office to work there. I think working in the governor's office or working anywhere in the legislature puts you on track to have those kinds of conversations with people who are also discussing policy, and also to learn from the more experienced people discussing policy and what factors they're considering and what history they know. Because the people in the Capitol, Deborah, how many years were you in the Capitol? 29 years. And so she's invaluable to PPIC because she has 29 years in the building where she's been around all of the policy arguments and the building of the budget. Even just being around it and in those conversations, how much you gain. And also a lot of job opportunities arise in that situation where you can go from committee or work for a member. I had the privilege of working for a governor, and I will say I saw raw power. I was a minion. I'm not even sitting at the table. I'm sitting against the wall, and his serious people are around the table. And I would hear him say things like, I want to pass this policy, but Governor, there's no legislation to do it. There's no vehicle for you to do it. Grab that bill, hijack it, gut it, and drop my idea in. And I thought, wow. And then I'm the prosecutor, so I'd say, this is how law is made? I stand up and talk about how honorable it is to the jury. This is how it's made. But I mean, it really gives you perspective on seeing how people, wise people, policy people are thinking about it over a long time, too.
Thank you.
You're welcome.
Anyone else?
Hi. What advice would you give to the law student version of yourself?
Oh, what advice would I give to the law student version? I would say to myself to calm down. It's going to work out. And I would say to myself, you have no idea how great it's going to be. The people you will meet, the opportunities, the things you will observe are not even things you can imagine right now. And so I would tell myself it's going to happen. Don't rush it. Don't get too worried about this. It's going to work out.
Such good advice. Anyone else?
Yeah.
Okay.
Yeah,
Wonderful.
Hi, I'll stand up so I can see you. Hi, I was wondering, you've touched upon this a little bit at the beginning, but if you encounter, or when you encounter implicit bias, how do you kind of approach that, especially in relation to your gender identity and your racial identity?
Thank you. That's a really good question. And I will say it's developed over time. So I will say when I was a prosecutor and a new judge was probably when I felt most unprepared to react to it. But I learned over time that sometimes in interfacing with people, I have to believe that where the place they come from is benign ignorance. It's not intentional, it's not hostile, it's not negative per se, it's just sort of who they are at that point in their life. So I almost have to say that the first couple of times from the same person or in the same environment, I try not to personalize it too much because I don't think it's aimed at me necessarily. But in time, once you might learn that it is something that's going to be repetitive or aimed at you or is intentional, then it does require some action on your part to confront it in some respectful, civil way, preferably with a witness present, in the sense of what you said and what they said. You know, and I want to say it's contextual because I appeared regularly in front of a Southern judge who kept calling me sugar. Mm-hmm. And he wasn't going to change. But I also realized I wasn't the only one he called sugar. And at some point, too, you know, you have to weigh, do I want to win this objection or do I want to fight with him over sugar? So I would try to win the objection. But in time, you know, you adapt and learn. Sometimes it's with humor. Sometimes it's taking someone aside. Sometimes it's doing it in front of the judge and just asking for a moment on the record and not bringing a lot of passion to it, just being very matter-of-fact and making a record of it. Because it happens in the power dynamics of law. Because ultimately what people are trying to do is win. And so sometimes it is win at any cost. Sometimes it's I don't care if I hurt you. You need to grow up and take it. But I mean, this job, this work, and this career in law, it is about winning for some people and only winning. And so it can be a relentless kind of environment. Sometimes it means you decide whether you want to stay in that environment. Sometimes you correct it. You get into a position of authority and you don't allow it to happen. And you call people out on it. And you give them ahead of time, if I hear this happening, if I see it happening, I'm taking you out over this. But it takes a while to get there to be able to do that. But once you do that, there's a real sense of karmic satisfaction that is cumulative when you do things like that.
All right, we have time for one last question.
Get to be chief, Courtney.
Yes.
Then you can take them all out. That's what I
guess we have two more questions. I see
Mary
Cassandra
Beth.
and one right there. Yes.
Hi, thank you so much for being here. My question relates to a comment that you said that struck me quite heavily as a 1L student. And I'd like to ask you how you, in the course of your career as well as your evolution as an individual, consolidate what you saw at the time as quote-unquote failures or mistakes with your drive and tenacity, and how did you manage to focus on continuing to build a skill set instead of kind of reminiscing about what you did or ruminating on what you did wrong? And thank you so much again. This has been wonderful.
Thank you. Well, I think we all ruminate on what we did wrong. We all also ruminate on what we could have done better. And yet at the same time, we have to recognize that that's done and it's past. And I think we should be kinder to ourselves, because if someone else does that in front of me, I certainly don't think 3 times about it. So we have to realize that for better or worse, we're often not the center of attention, and people don't notice or people understand, and we can't let that be defining us in the future. But I do think that we learn from our mistakes. We don't learn from our successes as much as we learn from our mistakes. And so it's good to sort of ask yourself and have that debrief with yourself about what you thought went wrong and what you might do in the future. But it is about practice and grooving it. But mistakes today are successes tomorrow. Even, just taking the Supreme Court opinions, a dissent today is the majority opinion 3 years from now. Things change, you evolve. And when you make mistakes and you evolve, you become a kinder person. You're more understanding when that might happen in front of you or to someone you're close to or someone you observe. And I think that we should be kinder to ourselves about that. And we are our worst persecutors, right? We're our worst critics and our worst persecutors. And other people don't even notice it sometimes when we do it. So I would say lighten up, because we're in a career of conflict. And if people didn't make mistakes, we wouldn't be in business.
That's a good point. Cassandra, do you have a question?
I can project too, if that's all right. I appreciated your theme about how good facts make good policy. And on that line, I wanted to ask, what is the best way that lawyers can empower non-lawyers, average citizens to engage in policy? Because a lot of times there can feel like these substantive educational barriers to making a change. So what would you recommend to people that are not in law school, maybe not engaged in governmental processes like ordinary citizens? How can they become better informed?
Thank you. That's really a hard thing to do today in some respects, because there are so many media outlets and so many things that grab our attention. And it's easier to take the easy, simple, entertaining things rather than to tackle the hard stuff. So I don't know that we'll be able to change people wholesale, because they are working or they have other challenges, or it's in childcare or raising a family, and they really don't have the bandwidth at this time necessarily to do the research. But as we know, and as a non-lawyer even, in order to make sure that we get it right, we consult multiple sources. So we read something, but we read other things, and we understand the motivation of the writer or the motivation of the media outlet. So we're well-rounded in the facts that we know. But I think what happens is that the greatest impetus for change for people is crisis. So it almost has to happen to them personally, because a lot of people aren't interested necessarily in our biodiversity ecosystem that's going away if we don't do anything about it. But also, though, it makes sense if you learn about salmon and you learn about indigenous people who see salmon as part of their family. I mean, I think it is it's through storytelling that we can help people understand and become more passionate about issues. Whenever I was in the legislature and I was trying to sell a policy or ask for a change, I was always told by them, can you make it personal? Can you tell us about it in a real person? Can you give us an example, tell us a story that we can better relate to?
All right. Thank you so much. We so appreciate your willingness to spend time with us this evening and all of your candor and insight and experience. It has just been an absolute treat to have you here. Thank you.
Thank you for your work and your discussion.
Thank you.
Thank you for getting the students to think about policy. And
oh my goodness, no, I share your enthusiasm for both.
It's
so
the global view of it that really
matters. Absolutely. So we have a reception here. We would love to have some pictures if you are welcome or open to that. If any students would like to get a picture.